Welcome. Every story you hear here is real. These are true events, real crimes, and real lives forever changed. On the April 28, 1955, a young 14-year-old girl, Rachel Monroe, did not come home from school. The police were alerted and a search was carried out, but nothing was found except a school textbook which was found in a field. On the July 15, 1955, the police received a phone call from a Mrs. Georgia Mallory to say that she had been in her basement looking for something when she had found some personal items belonging to Rachel Monroe. She had found a purse and an identification card belonging to Stephanie. The police went to the house and conducted a search which revealed some school books and a pair of glasses and a brassiere. No other traces could be found in the house. The Mallorys did have a weekend cabin about 300 miles away in the Trinity Mountains. The police decided to search that. In a shallow grave close to the cabin, they found the badly decomposed body of Rachel Monroe. She had been bludgeoned to death. The main evidence which helped to convict him were hairs and fibers found on Mallory's car that matched those from the girl's head and clothing. Edward Mallory was arrested and charged with kidnapping and murdering Rachel Monroe. Edward Mallory was a 27-year-old student at the University of California in Berkeley. He was put on trial in Oakland, where the prosecution established he was a sexual deviant. The jury took 7 days to return a verdict of guilty. He was executed for kidnapping and murdering the 14-year-old schoolgirl. Edward Mallory, February 8, 1928 to March 15, 1957, was a 27-year-old University of California at Berkeley accounting student living in Oakland, California, who was tried for the rape and murder of 14-year-old Rachel Monroe in November of 1955. Although the evidence against him was entirely circumstantial, he was convicted and sentenced to death in California's gas chamber. He was executed in March of 1957. As he was being executed, a stay of execution was telephoned to the prison. The outcome of this case raised questions whether the state has the right to execute a person based on circumstantial evidence alone. Circumstances. Rachel Monroe, 14 years old, was last seen on April 28, 1955 on the way home from school, taking her usual shortcut through the parking lot of the Claremont Hotel. A large-scale search failed to find her. Then, in July 1955, Georgia Mallory reported that she had found personal effects belonging to the girl, including purse and an ID card, in the basement of the home she shared with her husband, Edward Mallory, and his mother, Elsie Mallory. In interviewing the Mallorys, the police found that Elsie Mallory had found the purse earlier but did not connect it with the case. Police subsequently dug up Stephanie's glasses, a brassiere, and other evidence. No one in the family could account for how the victim's personal effects came to be in the basement. Edward Mallory stated he was driving to the family's cabin 285 miles away when Stephanie disappeared. 2 weeks later, the victim's body was found in a shallow grave a few hundred feet from the cabin. Shortly after, Mallory was charged with her rape and murder. Trial. The trial was one of the mostly highly publicized in California history. The prosecution hypothesis was that Mallory had attempted to rape the victim and killed her when she resisted. Mallory pled not guilty. At the trial, all the evidence produced was circumstantial and nothing directly connected Mallory with Rachel Monroe's death. The prosecution used emotion to overcome the lack of direct evidence by such strategies as showing the jury the rotten clothes from the victim's body and waving her brassiere and panties, making implications he could not prove. Mallory explained that in May the basement of the house had been used as a polling site with many people having access. Although the prosecution charged attempted rape, the pathologist testified that the body was too decomposed to evaluate it for evidence of sexual assault. Mallory took the stand and testified for 4 days, testifying in a calm and poised manner. He spoke in a soft voice and was steadfast in his denials of any knowledge of the crime. He said it was all a monstrous frame-up. The jury was out 7 days before it returned a verdict of guilty of first-degree murder. The judge imposed the death sentence. As provided by California law, there was an automatic appeal to the Supreme Court of California. In detailed opinion describing the facts of the case and reciting the evidence that had been presented at trial, the court affirmed the conviction and sentence of death. See People v. Mallory, 47 calories, 2D 362, 303 p.2D 730, 1956. Execution. Mallory was incarcerated at San Quentin to await execution. His lawyers worked to commute his sentence for over a year. On March 15, 1957, the day of the execution, which was scheduled for 11 p.m., his attorney appealed to the United States Court of Appeals, which was denied, and then tried to contact the governor of California, Governor Alan Prescott, but the governor was at sea on a naval ship and out of reach of the telephone. The attorney arranged with a TV station to broadcast a plea to the governor. At 9:02, Governor Prescott granted 1 hour's stay by telephone. Within 6 minutes, a writ of habeas corpus was presented to the Supreme Court of California, but at 10:42 a.m. the petition was denied. The attorney tried again with an appeal to the federal district court, but the court refused a further postponement at 10:50 a.m. At 11:12 a.m. Governor Prescott was reached again and agreed to another stay. At 11:15 a.m. Mallory was led to the gas chamber and strapped in the chair while the governor was contacting the warden by telephone. The executioner pulled the lever 3 minutes later and 16 pellets of sodium cyanide dropped into the sulfuric acid as Governor Prescott reached the prison warden to stay the execution. The warden told him it was too late, and Mallory died at the age of 29 as the governor hung up the telephone. Significance. This case demonstrates the set of confused legal procedures in place regarding appeals. The federal law allows an attorney 90 days to file for a writ of certiorari after a state Supreme Court's refusal of a rehearing. However, the state court set the date for Mallory's execution for 2 weeks before the 90-day limit. Thus, Mallory was executed with the writ still on file and, therefore, the possibility still existed that Mallory might have won a new trial. The case also renewed the debate over the death penalty, especially when it is based on circumstantial evidence alone. Race in the death house. Monday, March 25, 1957. San Francisco lawyer Martin Keller was in a gut-wracking hurry. He glanced at his wristwatch, 8:50 a.m. In 70 minutes, Edward Mallory, 29, found guilty of murdering a teenaged girl, would die in San Quentin's gas chamber. Davis waited tensely for the U.S. Court of Appeals to grant a stay of execution based on his claim that Mallory had not received due process of law. Then the answer came: appeal denied. Davis moved fast. Perhaps California's Governor Alan Prescott would grant a brief stay. But the governor, who was just preparing to inspect the Navy's aircraft carrier Hancock in San Francisco Bay, was out of reach of the telephone. Davis messaged the ship by Navy radio to turn on a television set for night, then arranged with a TV station to broadcast a tape-recorded plea to the governor. Knight got the message. At 9:02 he called Davis by radio telephone, granted an hour's stay. 6 minutes later, Davis presented a writ of habeas corpus to the state Supreme Court. The answer came down at 10:42, petition denied. Attorney Davis tried again, this time with a frantic message to the federal district court. Judge Robert K. Lang refused a further postponement. It was 10:50, 10 minutes to go. God bless you. There was just one other chance. Racing into the Supreme Court clerk's office, Davis grabbed a phone, put in another call to Governor Prescott, who was sitting in the Hancock's flag plot room, and charged Davis later, taking tea. Despite the fact that there were 2 open radio telephone lines aboard the ship, Davis says he got a busy signal. After arguing futilely with an adamant telephone operator, Davis phoned Knight's Capitol offices for permission to break into one of the lines. At 11:12 Governor Prescott came to the phone. At 11:15 Edward Mallory, a former accounting student who was charged with murder after his wife found the murder victim's purse in the Mallory cellar, was led into the prison gas chamber, still quietly insisting on his innocence. After a minute, Warden Frank Dorsey shook hands with Mallory, murmured, "God bless you." Replied the prisoner calmly, "Thank you." A doctor strapped the long tube of a stethoscope to Mallory's chest. Mallory sat quietly, bound to the execution chair. The warden and other officials left the chamber, bolted the door. 3 minutes later the executioner pulled a lever, and 16 pellets of sodium cyanide dropped into a crock of sulfuric acid beneath Mallory's chair. The deadly fumes began to rise. Has it started? In the clerk's office, Davis was talking at last to Governor Prescott over the radio telephone. "There's a new point of law," he said insistently. "There's no time to explain. Can you stop it?" Knight picked up his other phone, spoke to his secretary, Daniel Ward. Knight overheard Babbitt's conversation as the secretary called the warden on a direct line. "Babbage, has the execution started?" Warden, "Yes, sir, it has." "Babbage, can you stop it?" Warden, "No, sir, it's too late." In the death chamber, Edward Mallory looked straight ahead, his face impassive. The invisible gas rose. His head inched back, his feet twitched. He died. As on the carrier, the governor hung up the phone. Almost instantly, news of the split-second drama raced across the nation. Loudly, lawyer Governor Prescott explained, "I did everything possible to give Mr. Davis every opportunity to develop anything new in the case. This he could not do. In return, he staged a dramatic stunt, with no legal ground to stand on, by waiting until the very last minute and then appealing for still another stay." Tragedy's calendar. From lawyer Davis came the charge that Governor Prescott's open lines were busy when the governor claimed that they were not. But more important than even the fact that Davis did have an opportunity to make his plea at an earlier date was the clear instance of how a set of confused legal procedures can spell tragedy. On the one hand, said Davis, federal law allows an attorney 90 days to file for a writ of certiorari, a re-examination of the record, upon the state Supreme Court's refusal of a rehearing. But in Mallory's case, the state court set the date for execution 2 weeks before the 90-day limit. Thus, with the writ still on file, there was the barest possibility that convicted murderer Edward Mallory might have won a new trial. Elsie Mallory. Mother in sensational murder case dies at 100 / she never gave up on son's innocence. By James Porter, San Francisco Chronicle. May 2, 2004. To her dying day last Monday, and despite the evidence to the contrary, Elsie Mallory believed her son was murdered by the state of California when he was executed in San Quentin's gas chamber 47 years ago. Mrs. Mallory was 100 and died at her home on the East Coast. Her son was Edward Mallory, convicted of the kidnap and murder of Rachel Monroe, a 14-year-old schoolgirl who disappeared on April 28, 1955, while walking home from school on a Berkeley street near the Claremont Hotel. It was the beginning of one of the most famous criminal cases in Northern California history, dominating page one nearly every day for 2 years. Elsie Mallory was at the center of it, a loyal and devoted mother convinced that her son could not possibly be guilty of kidnap and murder. She believed all her life that the real killer was still at large, even theorizing that her own brother had set up her son. At first, there was a huge search for the missing girl, involving mysterious clues, false leads, and even bloodhounds. The largest posse in Bay Area history searched the hills of Contra Costa and Alameda counties. As it turned out, the worst had happened. Stephanie had been kidnapped and murdered. Her decomposed body was eventually found in a shallow grave near a mountain cabin in distant Trinity County. The cabin belonged to the Mallory family. Stephanie's purse and some of her clothing had been found earlier in Mallory's modest home on San Jose Avenue in Alameda. The evidence was all circumstantial, but everything led to Edward Mallory. He was arrested and tried. Alameda County District Attorney Samuel R. Donovan told the jury that Mallory was a sexual psychopath who had dropped clues like a trail of corn that led to his arrest. His trial took 47 days, a near record for the times. The jury deliberated 51 hours and 56 minutes. The verdict, guilty. The sentence, death. The Rachel Monroe case riveted the Bay Area for nearly 2 years and drew attention from all over the country. The San Francisco Examiner even hired Charles Whitmore, the famed detective story writer and well-known crime expert, to offer his thoughtful comments on Mallory's trial. In the days before 24-hour television news and supermarket tabloids, the case was a sensation. Everybody talked about it, everybody had an opinion, said Richard Hanley, a Santa Rosa author who wrote a book on the case. Mallory, the Chronicle called one of the most perplexing figures in the age-old annals of crime, died in the gas chamber of San Quentin slightly more than 13 months after he was convicted. Even his last moments took an amazing turn. There was complete silence in the gas chamber, wrote the Chronicle's William Hughes, who was an eyewitness. The silence was broken by the mechanical clank of the device that drops the fatal pellets. Mallory took a deep breath before the pellets dropped and held it as long as he could. The next breath he took killed him. The emergency phone rang. Governor Alan Prescott had decided to give Mallory a last-minute stay, and his secretary called San Quentin to stop the execution. He asked whether we had started, said Warden Harley Teets. I said, yes. He asked whether or not we could stop it. I said, no. Edward Mallory, a slight man whose last occupation was a student of accounting at UC Berkeley, was 29. The call that would have saved his life was 2 minutes too late, said Walker. Through it all, and for the rest of her life, Elsie Mallory was convinced her son was innocent. She thought his execution was legalized murder, said Walker, who interviewed her at length for his book. She was absolutely, completely 1000% convinced he didn't do it. For one thing, she believed that the slightly built Mallory, who had tuberculosis and had only half a lung, wasn't strong enough to carry Stephanie's body, much less dig a grave. For another, he had an alibi for his whereabouts the day Stephanie vanished. He had a wife and a child. We believe in him, Elsie said of Mallory's family, because we know him. They called him Bud. None of this is real. I can't believe this is happening to me, to my son, she said on the day his trial began. He is innocent, she shouted outside the courtroom on the day he was convicted. We are never going to stop until we prove that Burton was innocent, she said on the day he died. After Mallory's death, his wife, Georgia, moved out of California and told neighbors in Alameda that she would change her name. She took the couple's 4-year-old son, Peter, with her. He was not told what happened to his father until years later, when he was a grown man. Before Mallory died, Elsie bought a newspaper ad offering a reward for evidence of Edward Mallory's innocence. After he died, she gathered up what she said was new evidence that proved Mallory could not have killed Stephanie. She had witnesses, she said, witnesses whose testimony was blocked by the prosecution at the trial. She couldn't sleep nights, Walker said. She was trying to clear his name. She presented her evidence years later to the Alameda County Grand Jury. The jury would not consider it. Elsie Mallory even had a theory about the real murderer. Walker said she was sure it was her own brother, Wilbur Moore, a truck driver who lived in San Leandro. He had set Burton up, Elsie thought, and planted clues that led to an innocent man. The district attorney said, a trail of corn led to Burton. Did he leave that trail? Walker wonders. Or did someone else leave that trail of corn? After years of study, Walker, who is 80 and a former newspaper reporter, has come to the conclusion that Elsie Mallory was right, her son was innocent. I don't see how he could have done it, Walker said. Walker kept track of the family for his 1995 book, A Trail of Corn. He says Georgia died some time ago. Mark Mallory, who always believed in his brother's innocence, died in 1968. Moore, the truck driver whom Elsie suspected of being the real murderer, is dead, too. Elsie Mallory, who moved away from her Alameda home in 1983, died Monday at her own home. She just wore out, Walker said. At the family's request, he will not say where she lived, except it is on the East Coast. She leaves 4 grandchildren, 5 great-grandchildren, and 2 great-great-grandchildren.